go on the record and also on WebEx. All right, at this point we are on the record and we are also here via WebEx, and this is case number 2103-01424. There is both a 10 o'clock setting and an 11 o'clock setting for this matter. I'm going to first turn to the motion that's before the court in the 10 o'clock setting here, and that is here the respondent's motion to dismiss. And let me first of all highlight we are doing this in a hybrid fashion, and let me explain that. I see that I have counsel and the parties in the courtroom with me here. And then in addition, we're doing this WebEx because it is, there are still safety precautions being implemented because of the pandemic. And so rather than having it open courts where people from the public can come into the courtroom, we've facilitated things so that anyone who is wanting to watch from the public the court proceedings, they're able to do so via WebEx. Now, just so you know, what the way that this works is there's a monitor there, and you can see everything that I can see on my TV screen, not TV screen, but computer screen for the WebEx program. So you're able to see who's joining to watch the proceedings here, and that's what I mean by a hybrid fashion. We are doing matters in the TOOELE court programs now. In the TOOELE court, cases are being done in a hybrid fashion, and this case is the same. With that, I'd like to start with appearances on behalf of the parties. Let's start with appearances on behalf of the petitioner, please.
Good morning, Your Honor. Spencer McDonald here on behalf of the petitioners. The principal of the petitioners, Holly Jones, is here, and the proposed witness we have, Marta Johnson, is in the gallery.
Okay, thank you. And how about appearances on behalf of respondents, please?
Your Honor, Christian Beckett on behalf of Skull Valley Health Care and Skull Valley Health Clinic, and present with me today is Executive Committee Chairperson Candace Baer, and should testimony be required for later, she will be providing that testimony.
Okay, very good. And welcome to all of you this morning. And let's turn right to what is before the court then at the 10 o'clock setting, and that is the respondent's motion to dismiss. I will first of all indicate that I've had an opportunity to read the briefing. Thank you, counsel. I have found that helpful. I will also find it helpful to hear arguments today on the briefing. I've received a court courtesy copy of the briefing. I find that to be helpful whenever that's given to me, so thank you for giving me that also. It is my practice to give the entity who bears the burden the first word and the last word, and so with that, I will start here with you, Mr. Beckett, providing argument on respondent's motion. Then I'll hear from you, Mr. McDonald, and then turn back to you, Mr. Beckett, and give you the last word. So with that, you may proceed.
Up to the lectern, Your Honor, or from the bench?
Whichever is your preference. I'm good with either. So if you have a preference to be either at the podium or you may remain there if that's also better for you.
I'll come up to the lectern here.
Okay.
Thank you. I appreciate the opportunity, Your Honor, today. This is a motion to dismiss pursuant to the lack of subject matter jurisdiction that this court has and or the personal jurisdiction over Skull Valley Health Care and Skull Valley Health Clinic. It's important to notice that those two entities are tribal entities. They have been registered with the state of Utah. In order to register a tribal entity with the state of Utah, you need to be at least 51% owned by a tribe that under which the corporation was organized. In this case, it's 100% owned. There is no difference between the Skull Valley Band and the Skull Valley Health Care or Skull Valley Health Clinic, the named defendants in this matter, or respondents. It's important to understand some of the factual basis for where we are today. And this kind of goes into the 11 o'clock hour motion. But the Skull Valley Health Clinic and Skull Valley Health Care, I'm just going to refer to them as SVHC combined. But they run a recovery center by which they can provide residential treatment for people who are overcoming drugs and alcohol addiction. In their pursuit of providing a facility, Miss Holly Jones was contacted, and she had some property that she offered up for sale. And negotiations were entered into between Miss Jones and former counsel for SVHC, Benjamin Grindstaff, and ultimately rested on a price. The money changed hands. The expectation for the property was that it would transfer at some point after some remodels were done. The problem was that there wasn't a signed contract that vested property, but money changed hands. Why we filed the motion to dismiss in this matter is because this court doesn't have jurisdiction over the tribe, and there are other avenues in which Miss Jones and her companies should seek redress on this issue, specifically through tribal court. It has been the long-standing policy and the law of the United States is that a tribe can only be subject to suit where it waives or Congress abrogates, meaning that Congress authorizes a lawsuit. And so what we have here is we have tribal immunity. It's similar to sovereign immunity. The terms kind of go hand in hand, and throughout the ages of court proceedings, the terms tribal immunity, sovereign immunity, they kind of go hand in hand. Here's and subject matter jurisdiction as well. One of the issues is that you cannot waive subject matter jurisdiction. No one can agree, yes, we need to come into this courthouse. Right? If the court doesn't have authority to hear an action, it cannot. And that goes all the way back to Motley versus the Northern Railroad back in 1838. This is a long-standing provision. Went all the way up to the United States Supreme Court, and the United States Supreme Court said, I'm sorry, we don't have subject matter jurisdiction. Dismiss the action. And that's what's going on here. The tribe has not subjected itself by waiver to this court's jurisdiction.
Let me ask you to address this first of all. So I'm understanding Respondent's argument is that there's tribal immunity here, and the briefing I'm looking at the standard the law I'm to apply, the factors I'm to apply to determine that. The briefing got into whether there's a 5-factor test, a 6-factor test. There's case out of the 9th Circuit, case out of the 10th Circuit. And so could you respond to what is Respondent's position as to where this lies as to the factor tests that the court should be looking at? And I'm going to have you flesh out to me how you think Respondents have met that test. So is there a concession now that it's a 6-factor test through the briefing, or could you respond to that, please?
Well, there's a couple different issues. There's a slight split on the circuits, right? Obviously with the 10th in the Summerhold and the white factors in the 9th Circuit, right? But what the court needs to look at is the connection between the entity that is claiming sovereign status and the sovereign. And that's really what the test looks to, is what is the connection between the two. And again, we can even look as recently as the 2017 case as Lewis versus Clark. Not the old explorers, but there was a case out of the 9th Circuit where a tribal member had asserted sovereign immunity status. And the Supreme Court went through and analyzed whether or not the sovereign status should apply to an individual. And in Lewis, and we didn't really brief this, Your Honor, in our briefing because it's very distinguishable. But the key here is that there is an analysis to determine whether or not a court has jurisdiction. And that's, again, going back to look at what is the action. Who is benefiting by the sovereign status? And so that's Lewis versus Clark. That's a United States Supreme Court case. But going back to the white factors, which came out in 2014, or to Summerhold, or to BMG, all of them are kind of looking at the same thing, Your Honor. They just analyze the facts slightly differently. And what we need to look at is what's the nexus between the two. And in this case, which the SVHC is 100% owned and operated and even managed by the same governing body that manages the tribe. There is no effective difference.
Let me ask you this then. So I'm understanding respondents asking me to look at the connection between the entity and the sovereign tribe. Petitioners are arguing to me that I shouldn't even get to that question because I don't have to, because the distinction looks at whether there's an unincorporated entity or not, and they are emphasizing that the entities were originally incorporated under the laws of the state of Utah, that is the first factor, the first consideration the court should consider, and that I only look at the multi-factor test as to whether the entities qualify as an arm of the tribe if we're looking at an unincorporated entity. So what I'm really wanting to hear from both sides here is the starting point for the court. Is the starting point for the court whether or not the entities were originally incorporated under Utah laws, or is the starting point the connection between the entity and the tribal sovereign? Can you answer that question for me?
Well, I guess, Your Honor, it goes back to the question of what's an incorporated or unincorporated entity. Because in Utah, the law is an incorporated entity is an INC, a corporation. An unincorporated entity in Utah is any other entity. So they have two very distinctly different codes in Utah. One, specifically, when it's incorporated, or a company, right? And that's under Title... I believe I addressed this in my reply brief, Your Honor, but Chapter 48, 3A 10231, and that's specifically under the title of unincorporated entities, irrespective of whether or not this entity was incorporated in Utah or as a state entity and then subsequently modified or amended to become a tribal entity. There is no difference in the distinction. Now, counsel wants to make a big deal out of the fact that we have Summerholt here. Summerholt is analyzing Oklahoma law, which is different than Utah law. And there was nothing in his briefing about what Oklahoma law versus Utah law was the same or otherwise. And irrespective of whether or not Utah law, quote-unquote, applies, Utah has no jurisdiction over a tribe. They do not have the authority, and that can be found in the Harvey case, which came out in, I want to say it was 2017, in the Utah state here, where Harvey Rapids, and again, I didn't brief it because it's completely distinguishable.
Let me pause you there, because I don't think the petitioners disagree with Utah has no jurisdiction over the tribe. The critical question is whether these entities, the respondents, are an arm of the tribe, right? And what petitioners asking me to consider is I don't even have to get to the multi-factor test to determine whether these entities are an arm of the tribe. If I first take note of the fact that the entities were first incorporated under the laws of Utah. But let's take this. Let's assume that the court does have to go through the multi-factor test. Walk me through how, in fact, the respondent entities are an arm of the tribe. Can you go through? I'd like you to go through that multi-factor test. What you've indicated to me is it's a split jurisdiction issue. In some jurisdictions, it's a 5-factor test. In some jurisdictions, it's a 6-factor test. But the critical question is, one of the questions for the court is, does the court have to go to that multi-factor test? Is that the starting point or not? Let's assume it is the starting point and that the court has to look at whether or not the respondent entities are an arm of the tribe. Walk me through how the multi-factor test is met.
Sure. And this is in the breakthrough management or white, right? These are the BMG factors or the white factors.
Yes.
What I want the court to also take notice of is that all of the complained of incidences here occurred after these, I could be wrong, I believe these occurred after the entities were incorporated as or amended to a tribal corporation. The lawsuit here absolutely happened after the entities were amended to become tribal entities, right? And so I guess that also then begs a question is, does the court have jurisdiction over an entity? And this is not and I just want to raise this as a potential red herring and why Summerholt doesn't make sense for a lot of reasons, is that if the court has jurisdiction over an entity that was incorporated in Utah, but if that entity amends and becomes a tribal entity, does the court automatically lose its jurisdiction because now it's a tribal entity? And that's something that's not been answered in any of the briefing. But that has to be a thought that the court has, and why Summerholt probably doesn't make sense in a lot of situations.
Remind me of when the respondent entities were amended to be tribal entities.
I don't have that right in front of me, but I believe that they were amended in either late or in early 2021 or mid-2021.
So what I have before me is the petitioners are asking me to place special importance on the fact that the respondent entities were originally incorporated under the laws of Utah, the state of Utah. By contrast, respondents are asking the court to consider that at a later point, the entities were amended to be tribal entities, and that somehow with that amendment now has changed things, and that the importance is on that. Do I understand that you're asking me to place special importance on that amendment and telling me that case law to this point has not fleshed out the importance or the meaning of what the court should do with that amendment? Do I understand that that's your argument, or would you correct anything then?
Yeah, so I think that there's a couple different distinctions here, Your Honor. Specifically, whether or not it's an incorporated entity or not, within the state or not, has no bearing. And there's a case out of the Ninth Circuit up in Montana that ruled specifically regarding an employee dispute against a tribe, and whether or not that entity, which was a school, which was organized under the laws of the state of Montana, could be sued. And the Ninth Circuit said no. And it didn't matter whether or not it was incorporated in the state or a tribal entity. And one of the things that needs to be paid attention here, too, is there's a huge difference between the Creek, the Cherokee, the Navajo, and the Skull Valley Band of Goshutes. The resources that are available to a tribe in order to create a corporate code, right, that is all-encompassing or not, is a factor that nobody has looked at yet. But specifically, Congress has protected tribes, whether or not it's 1 or 300,000 members. It's the tribal status that matters. It's not how many members are in the tribe or their economic realities to be able to create a self-government or code or develop a governmental entity, right, and a body of law. There's nothing in any of the cases that say, well, these guys have codes and regulations and these guys don't, so these guys can't get the same protections as everybody else. So, again, I believe it's important for the court to understand whether or not it was incorporated under state law or subsequently amended to a tribal entity. The distinction is without a difference. And if you look at the white factors either way, it includes as the factor number 1, the method of creation of the economic entity. Now, what does economic entity mean? Economic entity, somebody who's producing a profit or running a business, right? Well, where does the money go? That's a very important question here. 100% of the proceeds from SVHC go to the people, not as payments to the people, but for their health and welfare pursuant to a contract that they have with the Department of Health. And it's important to understand why
100% of the profits of the respondent entities goes to the tribe.
Yes, they cannot be spent anywhere else.
That?
Yes, and they cannot be spent anywhere else. They cannot go out and start investing in stocks and bonds. They cannot send their people to university based on scholarships. It has to go for a very limited purpose. and that's pursuant to their contract with the Department of Health. Now, that is a protected document. It wasn't included in our information, but you have a declaration from Candace Bear who clearly states that that's what happens here. And in the Summerall case, it's distinguishable because that entity was not wholly owned. It wasn't even 51% owned by the tribe, right? And this is something that's happened throughout history over the last 50 years, is that a tribal member will organize a corporation, and then when they get sued, they'll claim tribal status. And sometimes that's effective, and sometimes it's not. It all depends on what the economic reality is. And the economic entity here is a healthcare entity that was established to provide healthcare for the people in the geographic region in which they have a contract with the Department of Health under the Indian Self-Determination Act.
So let me ask you this. I know that you're doing what I asked you to do, which is to go through the 6 factors of the multi-factor test, which determines whether or not the respondent entities are an arm of the tribe. And what you're asking me to look at is, number 1, that the entities are 100% owned by the tribe. Number 2, that the profits obtained by the entities are 100% go to the tribe. And you're also arguing to me that the care that the entities provide are 100% for the tribe. That's what I've understood so far, and I want to go to that last one. And I'm going to give you a chance to correct, but I think you may see the question I'm going to is what's been argued in the briefing is that last part, that the services of the entities are not only for the tribe, but appear to be for more than just the tribe. And so, again, what I'm looking at is what are you arguing in terms of how the multi-factor test is met? Could you address my concerns from the briefing that the respondent entities are doing more than just providing services to the tribe?
Right. They actually have a contractual obligation to serve anybody within the geographic region pursuant to their contract with the Department of Health. It's people who live in the TOOELE County area. There's a map that's drawn out. I don't have it. I'm not familiar with it. But there's other tribes that have other areas that are specifically designated that this way they don't have intertribal conflicts within giving overlapping areas, right? So you have the Confederated Tribe of the Goshute Indians. They have a space down, I think it's Sacred Heart? Sacred Circle down in Salt Lake, that they have a specific area that they have. And the Utes, they have a specific area that they have as well. Down in the South, they have the Mountain Utes. They have a specific area themselves. It is not limited to just tribal members. And quite frankly, it would be against any doctor's Hippocratic oath, theoretically, if somebody walked in and said, I need treatment, they say, I'm sorry, by the way, we're going to discriminate against you because you're not native. And it would be a violation of the law. Like, anybody who discriminates against somebody for services, that's a violation of the law. So I think it doesn't make sense logically. Legally, it would not be justifiable to turn people away under a status, hey, you don't belong to our club. And third, it's not even a part of the test, right? So the second factor was purpose, right? The purpose of this entity is to provide health care pursuant to a contract with the federal government, right? This is a federal entity. It is a federal medical facility.
All right, so we're looking at the factors. You've addressed the first one, the method of the creation of the economic entities, and you've pointed to the fact that they have been amended to be tribal entities, and that the economics are that the 100% of the profits go to the tribe. You're focusing on something different than for purpose. Then you're saying that just because the health care goes to more than the tribe members, the purpose is still showing that the entity is an arm of the tribe. Tell me what you would have me focus on for purpose. What is the operative inquiry?
There is 0 cases that petitioner can show, and it doesn't make sense that they would either. That they would even have it available. That purpose needs to be limited to serving your tribal members only as far as the services that you're providing. One, it's unconstitutional. Two, beyond that, every single reported case that we cite has a casino doesn't only serve members of the tribe, and casinos routinely are found as an arm of the tribe.
So you're arguing that the purpose of the entities is to provide services to the tribe, but there's no case law that would indicate that that purpose must be exclusive to the tribe and not other members. Am I following your argument?
Absolutely, and in fact, if it was exclusive, it would be unconstitutional.
Okay, I understand your point there. Let's have you move to the third factor then.
Right.
Unless there's something else you want to tell me on the second. I understand your position, though.
I've already touched on this, the structure of the ownership. It's 100% owned by the tribe. The executive committee, which is a 3-member elected body of the Skull Valley Band of Goshutes, are the executives of the Skull Valley or SVHC, both of the entities involved here. All of the decisions, the buck stops with them, right? For all intents and purposes, the management of the SVHC is 100% in furtherance of the interests of the band. The executive committee is on both leadership. They're running the show, right? There's no one else. No one else has an interest in this, right? And again, that's including the amount of control the tribe has over the entities. It's 100%. It's not 80, it's not 50, it's not any other, it's 100%. There is no material way you could separate SVHC management from the band management. They are the same in people and in responsibility.
All right, so factor number 3, there's structure, ownership, and management, including the amount of control the tribe has over the entities. And you're saying that all of the management, structure, and ownership is in essence the tribe?
Yes, the executive committee is the CEO. They have people that work underneath of them. They have different administrators that work underneath of them. They have doctors that work underneath of them. But all decisions regarding the entity are made by the executive committee.
Okay. And then moving you to number 4, the tribe's intent with respect to the sharing of its sovereign immunity.
Right. This is pursuant to how it was organized. The intention is and has always been, as noted in the Declaration of Candace Bear, is that the entity will share the immunity of the tribe. It is, by all intents and purposes, the arm of the tribe. It is the health care provider for the tribe. They go out and talk to other tribes and bring in other tribal members to come into to provide benefits for other tribal members. Their goal is to provide health care for tribal members and for anyone else that is seeking care. But their purpose is to provide health care for their members. Like, that goes back to the purpose, right? Have to keep the doors open. But, again, what is the purpose or what is the intent with respect to sharing of the sovereign immunity? The intent is it is the same. It's 100% managed and owned, operated, everything under the Skull Valley Band.
All right. And then number 5, the financial relationship between the tribe and the entities.
So that's going to be a little bit different. One is the financial relationship between the tribe and the entities is restricted pursuant to the agreement with the Department of Health, meaning the profits cannot go back to the tribe. The profits have to be used in a way that advances the health and welfare of tribal members. But it cannot be just handed back to the tribe because the tribe has unilateral authority to do what it will with the money that it makes. The difference in this situation is SVHC, all of those profits need to be accounted for to the Department of Health and then spent in accordance with the terms of the contract with the Department of Health. And that's something that is a renewable contract that if they do not follow the terms of the contract, they could lose their charter. Right? And so when it comes to the financial relationship, I believe the tribe invested some money originally to get it set up and running, but other than that, the tribe doesn't have a whole lot of money. And so